My mother was in her fourth round of chemotherapy when my brother visited her alone on a Tuesday afternoon and arranged for an attorney to come to the hospital room. I didn't know about the visit. I didn't know about the attorney. I found out the next morning at 6:47 a.m. when my phone lit up with a text from her. I need to tell you something. Your brother asked me to do yesterday. I don't think I should have. Can you come today? I still have that text, saved in 3 places, because when you receive a message like that from a woman in chemotherapy, from your own mother about your own brother, something in you understands immediately that you are holding something that matters, something that is going to matter in ways you cannot yet fully anticipate, and that your job right now is to protect it before you even understand what it means. My name is Caroline. I'm 43, and what my brother did in that hospital room is the reason I now know exactly how undue influence works, how it moves through the specific vocabulary of family trust, and how a single text sent at 6:47 in the morning can dismantle it completely. My mother, Diane, was 68 when she was diagnosed with stage 3 breast cancer. She was otherwise healthy, walked every morning, had retired 2 years earlier from a career as a school librarian, was learning to paint watercolors, and finding it genuinely funny how bad she was. The diagnosis arrived like something that had mistaken her for someone else. She started chemo 4 months after diagnosis, 6 rounds, aggressive, spaced 3 weeks apart. The side effects were real: fatigue unlike anything she'd known before, nausea, and what she called trying to think through a wet blanket to describe what it did to her cognition. She was functional during treatment. She knew who people were, she could hold conversations, she could make decisions, but she was exhausted in a way that made sustained judgment effortful. And she was scared, managing that fear partly by being agreeable, by not being difficult for the people around her, by going along with things that sounded reasonable when a person she trusted was explaining them. My brother Marcus is 3 years older. We had a functional relationship, different personalities, different lives, civil. He'd had a difficult decade financially, a divorce with significant debt, a period of unemployment, years of quiet help from my parents that I knew about in outline but not in detail. By the time of my mother's diagnosis, he'd stabilized, but those years of help had built in him, I believe, a particular understanding of how family resources move when the need feels urgent enough. My mother's will split everything equally between Marcus and me. She told me this directly at dinner 3 years before the diagnosis. Unprompted, practical. The way she told me things she wanted clearly communicated. I've divided everything equally between you and Marcus. I want you to know so there are no surprises. I filed that away as settled and finished. It wasn't quite finished, not yet. The Tuesday of the hospital visit, I was at work. Marcus had texted that morning saying he was going to sit with Mom. I replied with a thumbs up. Completely ordinary. At 6:47 the next morning, my phone buzzed. I called her immediately. She told me, carefully, that Marcus had brought an attorney to the hospital the previous afternoon. Not Howard, the family attorney who had known my mother for 12 years and had drawn up the original will, but someone else, someone Marcus had arranged, whose name she couldn't quite recall. Before the attorney arrived, while they were alone, Marcus had explained that the current will created a complicated tax situation, that it would be simpler for everyone if the estate went through him first as the older sibling, with the understanding that he would take care of my obligations to me informally afterward. He described it as administrative, as temporary. The attorney arrived at 4. She had never met him. He had no prior relationship to her. The visit lasted 30 minutes. She signed. She said, "He made it sound so reasonable. I was tired and he was explaining it, and it seemed like he'd thought it through. And then last night I couldn't sleep, and I kept thinking, Caroline doesn't know, and I thought, that's not right." I said, "Mom, what exactly did you sign?" She said, "I think I changed the will. I'm sorry. I think I changed the will." I said, "That's okay. I'm coming today." I was already getting dressed while she was still on the phone. I called an attorney from the hospital parking garage before I went inside. That attorney, Priscilla, who specializes in estate disputes, told me to do 3 things immediately: back up every text from my mother that week, ask my mother to write in her own handwriting a description of what happened on Tuesday while it was fresh, and call Howard. My mother sat up in her hospital bed and wrote 2 pages in her own hand, careful, slightly shaky handwriting from the treatment, signed and dated at the bottom without being asked. She understood why it mattered. I spent 4 hours with her that day, not interrogating, listening, the way you listen to someone who needs to tell you something that has been sitting on them all night. Piece by piece across those hours, Marcus had arrived at 2 and spent the first hour visiting normally, talking, watching television, the kind of comfortable presence she described as nice. Then he raised the will, framing it as something he'd been thinking about on her behalf, something to discuss while things were quiet. He used the phrase tax advantages. He used administrative simplification. He said the arrangement would be temporary. He said he would, of course, take care of my obligations to me informally afterward. The attorney arrived at 4. She had never met him. He had no prior relationship to her. The visit lasted 30 minutes. She signed. I asked her directly, when she signed, did she understand she was removing me as a beneficiary? She was quiet. Then, I think understood something was changing. I'm not sure I understood that Caroline was being taken out. Marcus kept saying it was administrative. That word, the specific, chosen word, the word that replaced the actual question, do you want to remove your daughter from your will, with something that sounded like routine paperwork, something you agree to because you trust the person explaining it, and the explanation sounds reasonable, and you are tired and scared and trying to not be a burden. Howard, when I reached him, was careful but direct. He hadn't been consulted. He said, if Diane had called me and wanted to make this change, I would have brought her in alone, without Marcus, and walked her through it carefully to confirm it reflected what she actually wanted. That's what the process is for. That process was entirely skipped. He paused. If you have documentation, this is worth challenging. I had the 647 text. I had 2 handwritten pages from my mother. I had Howard's account of what the proper process would have looked like, and the confirmation that it hadn't happened. I had an unfamiliar attorney with no prior relationship to my mother, arranged by the one person who stood to benefit from the change. There is something I want to tell you about Marcus's choice of attorney, the specific structural detail that mattered most to the legal challenge. Howard had known my mother for 12 years. He had drawn up the original will. He knew what she wanted and why she wanted it, and he would have walked into that hospital room with that knowledge as a frame of reference. He would have asked whether the change reflected what she genuinely wanted, separate from what Marcus had explained she wanted. He would have taken time. He would have required that my mother have independent time to consider before signing, away from the person who stood to benefit. The attorney Marcus brought had none of that. No prior relationship, no history, no frame of reference for who my mother was when she was fully herself. His job was to execute a document. He arrived, she signed, he left. 30 minutes. Priscilla, my attorney, told me early in the process the absence of independent legal advice is often the pivot point in undue influence cases, not the condition of the person signing. Courts understand that people can be both vulnerable and lucid. The question is whether the process protected their independent judgment. An attorney arranged by the person who benefits, with no prior relationship to the signer, arriving to execute a same-day document, that process did not protect her independent judgment. That's the argument. She was right. That was the argument that won. Priscilla, my attorney, told me early in the process, the absence of independent legal advice is often the pivot point in undue influence cases, not the condition of the person signing. Courts understand that people can be both vulnerable and lucid. The question is whether the process protected their independent judgment. An attorney arranged by the person who benefits, with no prior relationship to the signer, arriving to execute a same-day document. That process did not protect her independent judgment. That's the argument. She was right. That was the argument that won. Priscilla filed the challenge 4 weeks after the hospital visit while my mother was still in treatment. Marcus called the day after it was filed. Furious, not contrite, furious. He said I was making things harder for Mom. He said the amendment had been her idea. He said I was being selfish during a family health crisis. I said I hoped Mom's treatment went well. I said I'd talk to him through our attorneys. I hung up and wrote down everything he said. By that point, documenting everything was simply how I was operating. People ask me why not wait until her treatment was over. The answer is what Priscilla told me on day 1. Once the amendment was signed and unchallenged, it was the operative document. Every day it sat unchallenged was a day something could happen that made it challenging it harder. My mother was in chemotherapy. Filing while she was still in treatment was not cruelty, it was precision. I was protecting a document that reflected what she actually wanted, made when she was fully herself, from a document created in a hospital room by someone who had counted on exhaustion and trust to accomplish what honest conversation would not have. Marcus chose his timing deliberately. He visited on a chemo week. He arranged an unfamiliar attorney rather than the one who would have asked hard questions. He used the word administrative to describe something that was the opposite of routine. Every one of those choices was a choice. Challenging it while she was still in treatment was the appropriate response to that precision. The challenge took 7 months. My mother's chemotherapy ended during that period. Her surgery was successful. She participated throughout, gave formal testimony consistent in every detail with what she'd told me in the hospital room and written in those 2 pages. My mother's attorney argued she'd experienced a period of genuine lucidity that week. Fluctuating clarity does occur in chemo patients. It's a real phenomenon, and the argument wasn't frivolous. Our attorney submitted her physician's cognitive assessment 4 days before the amendment was signed. The scores placed her below the threshold our state's case law uses for testamentary capacity on a document of this significance. 4 days before she signed. The judge ruled the amendment invalid on 2 grounds: insufficient evidence of independent legal advice. The unfamiliar attorney had no prior relationship with my mother and no record of advising her independently of Marcus's presence, and the specific framing of the amendment as administrative and temporary when it was neither. A misrepresentation that compromised the validity of her consent. The original will was reinstated in full. Marcus did not attend the final hearing. I was there with Priscilla in a quiet courtroom, listening to a judge say that what my mother had written 8 years ago, when she was fully herself, was what would stand. I want to say something about the 647 text that I haven't said yet, something about what it took to send it. My mother sent that text at 6:47 in the morning, which means she had been awake for at least an hour, probably longer, lying in the dark after a chemo day, turning Tuesday afternoon over and over in her mind. She had been through the visit once and then again, and something in each repetition landed differently than it had in the room when Marcus was present and explaining, and the attorney was there with the document. Distance did what presence prevented. With Marcus gone and the treatment settling through her and the night quiet around her, what she'd agreed to in the afternoon started to look like what it actually was, rather than what he'd framed it as. She risked something by sending it. She risked Marcus finding out she'd told me. She risked a confrontation between her children in the middle of her treatment, which is the last place anyone wants a confrontation. She risked the comfortable possibility that what had happened was fine, administrative, temporary, exactly as represented. She sent it anyway. At 6:47 in the morning, alone, she chose truth over convenience. That choice is not a small thing. I have that text saved in 3 places, and I will keep it in 3 places for the rest of my life, not because I need the evidence anymore, but because it is the best thing she has ever done for me. My mother is in remission. That is the most important sentence in this entire story, and I want it to land clearly. Her will is what it was, equal, 50-50, what she intended when she sat across from me at dinner and said she wanted no surprises. That document is valid and reflects what she actually wants, made when she was fully herself rather than exhausted and scared and trying to be uncomplicated for the people around her. My relationship with Marcus has not recovered. We speak at family events. We are civil in the specific way of two people who have been on opposite sides of a legal proceeding and are now required to share holidays. He believes, as far as I can tell, that I overreacted to a practical arrangement. I believe he sat beside our mother during her chemotherapy and had her sign a document she didn't fully understand, using the trust she placed in him as the mechanism. Months later, my mother said, "I almost didn't send the text. I almost thought, maybe Marcus is right. Maybe I should just let it be." I said, "But you sent it." She said, "Something in me knew it wasn't right, and that was enough to reach for the phone at 6:47 in the morning." That is the whole story underneath everything else. She knew. She reached for the phone. Everything followed from that. Subscribe to Family Verdict for a new family betrayal story every week. If someone has ever used a vulnerable moment to change something that should never have been changed, tell me what happened in the comments below. I'll see you in the next one.